Welcome to the Planning for Life podcast with certified financial planner professional Russell Jacobs and financial life advisor Carl Coolidge. Carl and Russell will share creative strategies and ideas for overcoming challenges in your personal and financial life. Inevitably, life happens, and we will empower you to reach your destination. Thanks for joining us. Now, on to the show.
Hello and welcome to another Planning for Life podcast. Today, Russell and I are going to talk about some common objections that he has heard in his career about estate planning. Now, before we get rolling on all of this, I need to say just a couple of quick disclosures and disclaimers. Russell is not a practicing attorney. He is not an estate planning attorney. What Jacobs, Coolidge Company does is they facilitate conversations with their clients because we know if those conversations aren't facilitated, then they generally don't happen. And if they don't happen, well, then stuff doesn't get taken care of, which is what we're going to really dive into today. But even better, Russell just got off the phone right before our podcast with a family talking about some of these estate planning things. So, Russell, before I start firing off some of the questions that I have for you today, would you mind telling us a little bit about the conversation you just had?
Absolutely, Matt. This is a family that I've worked with for a number of years now, since the early 2000s. In fact, it's a good example of the type of relationships we have with our clients because the son of the father actually referred me to him. Father came to him and said, I'm just not comfortable and happy with the person I've been working with on our estate planning, the non-legal aspects. Who would you recommend? And so this son called me and said, would you meet with my father, but be prepared. He's a stickler for details. I'm like, I'd be happy to do so. And he said, if you can get my father, then I'll become your client too, because he's a complex person, very sharp. And that happened to come true. And the father became a client, the mother and father, and then the son and his wife became a client as well. And what we are simply doing today is trying to talk about how to organize an understanding of all of the estate planning, the various trusts and things, and actually revisit their goals and objectives for the planning. Because one of the things that happens is the laws are constantly changing. So whatever wills, documents, whether they're just basic wills or complex wills and trusts, you have to review and update them for changes in the law. And so we were talking about it at this point, and so we're fast forwarding 20 years. The mother has passed away, and so we're talking about how to communicate with entire family now because the grandchildren are grown, and it's all about communication. Because another thing we see, and this is not at any economic strata, this is just up and down the economic spectrum, is even people that they prepare the money for the family, but not the family for the money. And so how much money happens to be inherited by children is a lot of money wherever they are in the economic spectrum. So if you don't prepare them for it, you're creating the probability of a bad outcome. So anyway, we were just talking about all that and then how to bring the rest of the family into the fold. And another challenge was, as we get older, sometimes you have to make changes to the team that you've worked with. And so we're looking at bringing in a younger attorney to add him to the team. In this case, it's a him. Of course, it can be a her too. And how to go about that, because that's one reason people don't do estate planning, because the details can be sticky. They can be uncomfortable. They can hurt people's feelings, but hurting people's feelings in an appropriate manner, meaning nicely and professionally, is better than getting a bad outcome. And that call was supposed to take half an hour. It took an hour. And that's often the case too. People think it takes too much time, but I could go on all day about that, but I'll stop and let you ask me another question.
Well, I mean, you really just queued me up for one of them, which is, I don't have time. Many people think that the legal process with documents and all of the organization that you have to have as the recipient of the trust or of the estate plan is just so labor intensive that a lot of people, especially towards the end of their life, Russell, don't seem to want to do it. What do you think about that?
Well, I think my personal experience is once people hit the age of 75, not much happens after that. They just don't want to change anything. But the earlier you start, the better. And you could argue more important because people tend to think, that it'll be fine if they die without a will. But in whatever state you live in, if you die without a will per se, you still have a will. It's the state will. So whatever the state laws of intestacy, they're called, are, then that's what you're going to have happen. And in the case of kids, the surviving spouse may have to go to court to be appointed as the guardian. The surviving spouse will inherit a spousal share of an estate. It doesn't just all go to the surviving spouse. They'll be the shepherd of it for any children they have, but they have to be a steward of it. It's not theirs. And there can be a lot of unintended consequences. There can be unexpected challenges to the asset. And it's going to cost you time and money and stress, if nothing else, even if you ultimately get the outcome that you thought you would. So, getting a basic will and the ancillary documents that support that, like a power of attorney, a healthcare directive, and a living will, is not that expensive. They get more expensive when you get more complexity, but it's very affordable, and it's just a matter of organization. The more organized you are, the more affordable it is. The less organized you are, the more it costs because the more digging that has to be done by the lawyer, the more it's going to cost because they work based on time. So one of the other advantages of working with Jacobs Coolidge is we get you organized. We sort through the goals and objectives where you are now. We create your balance sheet and all the titling of everything and birth dates and all those details. And we are able to give that to your lawyer on a silver platter, and they actually enjoy that very much. So it creates a much more efficient process. It actually drives the cost of your lawyer engagement down in most cases.
So many people just believe, and you answered this, so I'm going to use this as a bridging question, that, well, my heirs know what's going on, so therefore I don't need a trust. And we know that they do. If not, it'll go to probate. But what about just assuming that your spouse will get everything anyway?
Yeah, that's a very bad assumption. And you know what they say about making assumptions. It makes something that starts with an A out of you and me. And it's a three-letter word. We'll leave it at that. It really is not correct because A, they don't know what you think they know. And B, anytime there's gray area or gaps that have to be filled in, you don't get as good an outcome. And, certain things, if you plan properly, you can avoid probate. And in some states like Georgia, where we live, probate is not onerous, it's not expensive, but it's still public. And certain states like California, Connecticut, New York, places like that, it's very expensive. And so people often use living wills for that because that avoids probate. And if you gain and want privacy for your affairs, you have to be proactive in the actions that you take. But most importantly, you want to communicate with your family so they understand why you did what you did. Because you see, hurt feelings often when you don't convey the why behind the actions that you took. And so then they're left to wonder why you gave the family heirloom to Jane and not to John. And sometimes you see the biggest conflicts between family members over the smallest item, not necessarily the money, although the money is a big deal too. And
Russell,
go ahead.
let's go into that, just because you just opened a door that I want to walk through with you, which is, this is a difficult conversation. It's not something that a lot of people are comfortable with because they don't want to think about it. But some of those things you just brought up, that brings that whole idea of fair, not equitable, and truly not being able to feel that when you are on your deathbed that your stuff's taken care of. How do you facilitate a conversation like this, especially when you see resistance?
Well, you basically want to try and paint pictures of potential outcomes because really, it's about a factor of pain. And do you want to have the risk of pain yourself, knowing that certain dreams for your family aren't going to be realized because you didn't get the work done? Or do you want to inflict pain, emotional pain on the next generation, possibly multiple generations, because you didn't do something? Because certainly the path of least resistance is to not do something, to not take that action. but it's a game changer in some cases for generations. And I have a personal story here too, because my father was a farmer, believe it or not. Thank God, Dad, you got out of farming and went into the insurance business, which is evolved into Jacobs Coolidge. I appreciate that very much. That was in 1962. But he was a farmer before that. His brother was a farmer, and my grandfather was a farmer. My father left, moved, got out of farming. My uncle stayed in farming, and my aunt was never involved in the farm. When my grandfather died in 1973, he left everything to all three kids equally, and which really hurt my uncle who had stayed on the farm. And looking back, I understand this completely. And then the uncle had to buy the two-thirds interest from my aunt and my father, and that created a 30-year schism in the family, which didn't get resolved until the people got old, meaning my father, aunt, and uncle, and realized, hey, we're old, we need to get over it and all that. But family business is one of the places where this creates the most conflict, because it's very common that you're going to have one child or sometimes two, but you have children that stay and children that go. And then often the parents, wanting to be fair, leave that business equally to everyone, meaning all the children. And it can create a death sentence for the business if those who stayed have to raise capital to buy out those who didn't. And there's an easy way to create equalization. It doesn't involve unfairness to any of the children and makes the business much more likely to stay viable through the proper use of life insurance. It's just about understanding your goal and understanding the damage or what's going to happen possibly if you don't do it. So that's a long way of getting back to your question: is what do we do? We try and paint uh, vivid, visceral pictures of what's going to happen if you don't do this. And is the pain of not doing worse than the pain of having to allocate time and resources now? And it usually is. And so it becomes a question of, can you get the people to the point where they're willing to take an action?
What happens if they made a will a long time ago? Is there like a statute of limitations on how long a will is in place? Again, understanding you are not an estate planning attorney, you're not a practicing attorney, but you do deal with this in the planning process and especially the legacy process when you pay out life insurance benefits. What happens? I mean, so you were just talking about the conversation that you had right before we started podcasting today, that you were updating things. How often should somebody update their wills and trusts? And then number two, why? Why do they ever need to do that?
Okay, well, I would say how often is a function of your situation. If you are moderately well off and your situation is not changing that much, there's not a lot of reason to have to change it. I mean, things that might cause you to change it. We see a lot of children who are become adults, they have children and they don't know who they want to be guardians and their wills, or, take over if something happens to them. So they name their parents, and we discourage that because the parents are older. And then if you go 10 years, they're much older. And so you want to make sure that you think through who you're going to name in your will to step in for you as power of attorney or guardian of your children if you're not there and able to do so. And that's the kind of thing. And you want to have to pick two or three people, the primary and then two backups, in case the people you chose won't or can't serve. And then those people change, people move, relationships evolve. And so you need to periodically look back and see who you have listed in your wills. And then also your situation changes. People die, people get divorced. Some of these things will invalidate wills. And if you haven't redone your will after this happens, then you're back to those state laws of intestacy. So, really, just as your situation changes, you could use kind of a fact pattern test. If nothing's changed in your life, perhaps you don't need to update your wills. But if you've had changes, you should revisit that. As your children get older, perhaps you should revisit that. If you become more successful, you should revisit that. And then as it relates to another reason why the estate tax and laws of income and estate taxes are constantly changing. And we've gone from, in my 35 years in this business, we've gone from various taxes. $600,000 was as much as you could leave someone without tax. When I started doing this, it went up to 3 million, 5 million. There was a year, the year George Steinbrenner died, it was zero. So he picked a perfect year to die. Then no one would have ever guessed during the previous administration that the exemption would ultimately go up to the 11 plus million that it is right now. But a lot of money is being put out by the government. Revenue is going to have to be raised. It's very possible that that number could come back down to a much lower level in the future. So all of these changes should cause you to go back and revisit the planning that you've done. And then again, whatever planning you do, you need to communicate that with your family when they're old enough to have it done. You also need to communicate to the people that you've included in your documents that you've done so. And I mean, ideally, you'd ask them first because it is a very important role. And then I'd say also importantly, if you're asking someone to become the guardian of your children, you better have enough life insurance or assets or some combination of the two to make it comfortable for them to get that job done properly. Because what person, when they're thinking it through, would want to leave their children to someone when already a tragic situation's occurred and leave the people in financial straits who they expect to take care of their children? And it happens all the time.
To wrap up today's podcast, I'd like to talk a little bit more about the executor, the trustee, the guardian, those sorts of positions. How in the heck does somebody choose that stuff? I mean, a guardian is different, right? Because that would obviously have to do with your children or pets or things like that. But let's talk about the trustee and or the executor of the state. How do you figure that stuff out?
Well, you want to sort through that really carefully, just like you do when you're picking your guardian. But it can often be a family member. You just want to make sure that you're picking someone who has the educational and mental capacity to do a good job, and you want to give them indemnification if it's family members. So because they're often a family member won't charge to do that role, and that isn't that great if you don't charge and then someone sues you, so you can protect them in the document. But often we have corporate trustees either serving in a co-trustee capacity or a successor capacity where if the individuals can't serve, you have a corporate entity, or if it's down the road, or if it's more assets, you ultimately would like to have a corporate trustee who can make sure the wishes of the grantor of the will or trust actually that the wishes get carried out. So it can be a friend, it can be a family member, or it can be that individual in conjunction with the trust. And often lawyers end up probating wills and serving in that capacity. If you have a more advanced estate, that can be a good decision, but you want to have that conversation too, meaning the fee conversation with the lawyer, so that you don't want the assets that you have at death eaten up by fees and expenses. So you just have to think through who do you think will serve you and your family well, and spend a lot of time with that on the front end. Because if they're serving in that capacity, that means you're no longer with us.
My favorite question to ask during these podcasts is, well, what did I miss, Russell? What sort of questions should I have asked you about objections or estate planning or things like that, just that I might have missed that your experience might be able to answer for our listeners?
Well, I think that the biggest thing is it's not going to happen to me. And so, or I'll get around to it later. When you think about the negative impact on your most precious assets, and I'm not talking money, I'm talking about your family, your loved ones, your children, and it's not just them. It's a intergenerational impact. So it's really that procrastination. We've talked about procrastination before, and that it's not going to happen to me, or you don't want to spend the money to get it done when the cost of negative impact on your family is incredibly geometrically more costly in a negative way than the few hundred or $1,000s it would cost to get this will done. And I would say people just don't go seek it out. You go speak to several attorneys until you find the right one, because I promise you there's one out there. As we know, there's a lot of attorneys out there. But I think too, it's coming back to be organized. be thoughtful about this. What do you want? And who do you want to get what? And do you want to leave a legacy to a charity, a college, or whatever? And just have the conversation with yourself and then with your family, and then execute. Don't procrastinate. So that's what I'd say is just I'm reminding people to take action. Don't procrastinate.
Russell, what a great and timely podcast that you just had a client on the phone talking about trusts and legacy planning, and also taking some time today to meet with our audience to talk to them about something that is very, very important for them to have really good communication about, but especially having it with somebody that they already have a relationship with, somebody who knows how to facilitate these conversations, and somebody who truly cares with the outcome of that decision, and the planning processes happen. Really does make a huge difference. So Russell, thanks for being on the show.
Thank you, Matt. As always, I appreciate you.
If you have not subscribed to the podcast, make sure you click the subscribe now button below. And also, if you know somebody who would like to be able to listen to this podcast on YouTube, Russell and Carl now have a YouTube channel that you can subscribe to make sure that you keep up to date on all of the great thought leadership that Russell and Carl will put out into the marketplace. So for Jacobs, Coolidge Company, this is Matt Halloran, and we'll see you on the other side of the mic very soon.
The content is developed from sources believed to be providing accurate information. The information in this material is not intended as tax or legal advice. Please consult legal or tax professionals for specific information regarding your individual situation. The opinions expressed and material provided are for general information and should not be considered a solicitation for the purchase or sale of any security. Russell C. Jacobs III, Carl B. Coolidge, James Jacobs, and William Schwartz are registered representatives of and offer securities, investment advisory, and financial planning services through MML Investor Services, LLC, member SIPC, Supervisory Office, Jacksonville, Florida. Jacobs, Coolidge & Company, LLC is not a subsidiary or affiliate of MML Investor Services, LLC, or its affiliated companies.